What's up everyone, it's a Law School Lumberjack here with another video, and today we're going to talk about the doctrine of unconscionability. So unconscionability basically involves using a very extreme inequality of bargaining power so that the party with more power is able to extract a lot of value out of the deal. Now, what's really important here in the kind of push and pull we see is, there's nothing wrong with having more bargaining power. Right, and that's what the courts wrestle with in a lot of the cases, such as Morrison, Harold and Kreuziger, and Lloyds Bank and Bundy, which are some Canadian cases that we study in law school. We see a this kind of push and pull between the fact that someone has bargaining power and dictates terms in a contract that are more beneficial to the party with the power is not in and of itself unconscionable. That's just how bargaining works, and yet at the same time the courts there's a threshold upon which, when that threshold is crossed, the courts are going to say getting that deal was unconscionable and we can hold this contract to be voidable. One of the more important things to remember is that a contract that is unconscionable is not void ab initio as a general rule, it is voidable. And that's something that if you're interested in, you can see my previous videos on void ab initio versus voidable contracts. Basically what this means, to keep it very brief, is that only the weaker party can bring up that the contract was unconscionable, and additionally the contract isn't void from the start, it's void when the courts declare that the contract is void. So what is the test for unconscionability? The test for unconscionability, first thing you have to prove is that there was an inequality of bargaining power. Obviously, if you have two parties on a level playing field, there's no real bargaining or inequality of bargaining power to take advantage of. So basically there has to be an inequality of bargaining power, and I would suggest it probably has to be a very substantial inequality. Additionally, that bargaining power, and this comes up in a case called Morrison, that bargaining power generally arises from something beyond just the normal course of business. It usually involves from ignorance, a need, or distress of a party. So it's not your typical bargaining power in the market. It's something that usually arises from some external source that causes someone to be, essentially, for a lack of a better word, desperate. And the desperation leads to an increase in the bargaining power. Now, the second part is that you have to prove that there was substantial unfairness that was taken advantage of by the stronger party at the expense of the weaker party. So essentially, you can't have a situation where there's just an inequality of bargaining power and a reasonable deal is met. There has to be some substantial proof that essentially the stronger party took advantage of the weaker party. Once you have met that two-part test, it is then presumed that the stronger party did take advantage, that the contract is unconscionable, and therefore that the contract is unenforceable. So once this presumption has been found, the stronger party then has the ability to rebut this presumption by proving that the deal was fair, it was reasonable, and it was a just deal. So it's not as if you prove these two items and then the stronger party's dead in the water. The stronger party has the ability to rebut the presumption, but the onus shifts to them. So the burden of proof and the onus shifts to the party who had the bargaining power, the higher bargaining power, to then prove that the deal was not unfair. So that's the general rule for unconscionability. Certain other cases can bring up other items, such as looking at whether or not the deal would be, and the situation and the facts surrounding the deal were reasonable and would be accepted by the community standards of a society. But the general rule, or the general test, is that two-part test with the rebuttable presumption. So what you're here for is probably, what do I do on a law school exam? So on a law school exam, if you've got unconscionability on your mind, what you're probably wanting to look for is a situation where there's a stark inequality of bargaining power, and then some advantage gained from that inequality. Now, on a law school exam, it's probably also important to note that, how stark is that inequality of bargaining power? As I said before in my example, if you've got, a supplier and a purchaser, and the supplier's got slightly more bargaining power than the purchaser, unconscionability has no real merit. Now, conversely, if you have a situation where a used car dealer takes advantage of, let's say, a young adult by using marketing tactics that are immoral, then you might have a situation where the young adult truly was faced with an inequality of bargaining power, and his free will to create the contract was vitiated. In that situation, you might have a situation where unconscionability actually has merit, or an argument with respect to unconscionability arguably has merit. The two-part test would arguably be made, and the onus would shift to the used car dealer to prove that the salesperson essentially created a fair and just deal. I hope this video is helpful. Please like and subscribe if it was. Take care. See you next time.